Probation, parole, two words that sound like second chances, but if you've ever been through the system or worked in it like I have, you know the truth. These aren't lifelines, they're tripwires. And when you trip, they're standing there with a violation report in a cell waiting for you. Today, we're pulling the curtain back with Mike Walters, the guy who wrote the article, Probation and Parole is a Trap. He's not some pundit. He's a researcher, a watchdog, and he's exposing what your judge, your prosecutor, and even your probation officer hope you'll never figure out. So sit back or stand up and shake the system, because we're diving deep into immunity, marijuana myths, and why your seatbelt might cost you your freedom. Yeah, I think it's definitely a delay here.
Yeah. Seemed to log on a lot smoother, though. So,
yeah, I think Mike Walters with me. He wrote an article, Probation and Parole is a Trap. And I feel horrible, Mike, because this is about the fourth time that I've asked you this question, and you were like in mid-answering of each time where we were cut off. But what inspired you to write the article? Mike talks about police misconduct in his community and how he began studying probation law and discovered overturned rules still being used.
Well, I studied a lot of what goes on in my community and everything. I did articles on the local law enforcement community. I realized there was a lot of I don't want to say corruption, but like a lot of misconduct in my local police force that was never reported to media or anything like that. So I started just, piecing together, looking at other areas, and I studied the probation area and realized, they have a set of rules, and all these rules are what you want to call appealable. You can argue them in court and things like that. And I've learned a lot of case laws that came from a lot of these rules and everything. A lot of them were overturned. Some of them were affirmed by higher courts and things like that. So I just basically studied, these set of rules and everything. And I discovered that the probation department has lost a lot of power over the last several years. But they don't necessarily tell probationers or defendants or anything like that.
So, I mean, did you initially start seeing it become more punitive at some point, or when you were doing the research on it?
Yeah, I started discovering like a lot of the rules were in courses, and probation department don't go by higher courts. They just have and in a sense, it's. I'm a big fan of psychology and what the public doesn't know. So they love a lot of people who are on probation that don't know what the rules are, what's been overturned and things like that. What the public doesn't know, it benefits them.
So you describe probation as walking a fine line that can easily snap. Can you explain what that line looks like in real terms for someone like on community control or probation?
Well, the fine line is like if your probation officer doesn't like you, or if the judge doesn't like you, or even the prosecutor isn't really too fond of you, they all work together. They're all friends. They all work together. And so that's the fine line there is, you got different avenues where, your probation could be violated. There's something called immunity in the judicial system. For example, if you violate your probation, they say you violate your probation, you don't have due process in probation violation hearings. You don't have.
Think probation officers just check your paperwork and wish you well? Try unchecked power, no oversight, and legal immunity stronger than most cops even dream of. And the kicker? most people on probation don't even know the rules they're supposed to follow, or that many of those rules have already been overturned in court.
You don't have certain rights. You don't have a right to a trial. It's basically a bench trial with the judge, and probation officer doesn't have to prove really too much to violate, your probation. And that fine line is, even if you did not violate your probation, the judge could always, still vote agree in favor of the probation officer because they have immunity. Whether it's right or wrong, they still have immunity, and they know that you have an appeal process. So that's the whole fine line there, is these probation hearings doesn't really help you in your favor, I guess.
And it's actually a topic that I'm becoming very well versed in as far as the qualified immunity. And a lot of people are, I think, I don't know, they're surprised at my position coming from prior law enforcement. I'm pro cop, just not pro corruption. And qualified immunity is,
right,
just so everybody understands, I haven't spoken about it a lot yet. I plan on doing so, but qualified immunity is one set or standard that Mike's talking about. And then there's actually what's called absolute immunity, which judges, prosecutors, and probation officers have. So you have qualified immunity, which is a pretty high standard for law enforcement. But then you have absolute immunity, meaning that they could literally be doing something totally, completely unethical or illegal, and there's not a lot you can do about it with judges, prosecutors, probation officers, because probation officers are an extension to the judge. I didn't want to go off in the weeds on your interview, but I wanted to stop because a lot of people have contacted me relative to that. I have a very, again, my position is this: if you're performing your duty the way you should be, you shouldn't have to worry about qualified immunity. Shouldn't have to worry about these issues. And it's very scary, that a judge has qualified immunity, that a prosecutor can do completely illegal acts, and there's not much you can do about it. But again, I apologize. I just wanted to make certain that everybody understood where you were coming from, what you were talking about. I think it's a very relative topic. But
and judges, prosecutors, and like I said, probation officers. Probation officers has the powers of law enforcement. Basically, they have the power to arrest you, search you without warrant, things like that. When you look at judicial immunity, they know that you have a right to appeal, so they can make any decision they want. If that appeal comes back and they get reversed on their decision, when I say their decision, it's the judge's decision, but the judge doesn't care if his decision get appealed. He's going to do whatever he wants because he has that judicial immunity.
And also another alarming thing, and again, I apologize going off weeds. You're bringing up appeal, which I think is also sort of laughable, because people will say, well, hey, if the person got, if something happened in court and they got convicted wrongfully, hey, they can appeal it. But that is an entire process in itself. And I've known people to literally serve out their entire prison sentence by the time the appeal is heard and comes back. And it comes back, yeah, they were violated. Their rights were violated, but they've already served 2 years in prison. So I find it comical when people just bring up and say, hey, if something happens, it's appealable. And like you said, Mike, once that happens, the judge doesn't care. It doesn't matter that they just sent some innocent person to jail for 2 years. But
right.
So
hold on real quick. I'm going to turn on my light.
Sure.
There we go. I had turned off my light earlier, and I'm going to turn it back on because it's getting a little darker now.
So your breakdown of the obey all laws clause is one of the clearest I've actually seen. Can you explain the difference between a technical violation and something that's actually willful and substantial?
I'll start with the willful and substantial. When you break the law, willful and substantial, basically you're breaking into a home. You're committing armed robbery, that's willful. You know that you're breaking the law. You're doing it on purpose. And that's where the willful and substantial comes into play. You know you're breaking the law. You know you're committing, you're basically breaking the law, violating your probation. That's willful and substantial. Now, something called technical law or technical laws, like everyday laws, like if you're driving down the street and you're going, say, 42 miles an hour in a 35 mile an hour zone, you're not technically, you're breaking the law, but you're not doing that on purpose. It can be an oversight, things like that. Not having your seatbelt on. I've not put my seatbelt on many times. So every day, these are called everyday laws that are being broken pretty much by common people. Another example would be like if you get a local citation for not cutting your grass for weeks on end. That's not willful or substantial unless you're saying, hey, I'm not cutting my grass. I hate the local government. Now that would be considered a probation violation because you're doing it on purpose. But if you are indigent, if you're not working, if you don't have the means to buy a lawnmower or pay someone to cut your grass, and that's willful. That's not a willful law that you're breaking. So those are two differences in those laws. And I've seen where probation departments has come out and said, if you get a traffic ticket or something like that, they don't consider that as being a violation of your probation because that's considered, a law that a lot of local law enforcement looks for every day, pretty much a citation. And it's hard to put someone in prison because you went 6 miles over the speed limit or you didn't put a seatbelt on. These laws are not technically jail term laws anyway. So,
but technically, just a question to you. So, but let's say you have a probation officer that does not like you. Could they do it? If you were caught speeding? Okay. So I just basically wanted to come back.
Oh, absolutely.
Yeah.
Because they will go back to that clause and says, well, technically that's violating the law.
So and this is actually I'm sorry.
But a different. But defense to that is if other probation departments are not doing it in the state of Ohio, keep in mind we have 88 counties. If you look at all their policies and stuff, I believe I've seen 2 counties where they said that they don't consider traffic laws as violating probation. It's possible you could use that in court because if one county is doing it another way, then, I think a higher court would look at that and determine, hey, he shouldn't be violated on this as well. Again, probation officers has to do that. They have to show that it was willful and substantial. But at the same time, they got immunity, as we talked about.
So the next question is something, it's a hot topic or hot button topic. And I mean, people went to the poll. They voted on it. They said, hey, we want to legalize marijuana in Ohio. All right. So even though marijuana is now legal in Ohio, you explain why it's still banned for probationers. And so can you basically walk us through how federal law creates that contradictions and how it's used against people?
Yeah, probation departments, they're going to use that federal law because they're going to go to that that rule that we talked about earlier, violating all federal, state, and local laws. They're going to fall back on that because, well, marijuana is still legal on the federal level, which is true. So they're going to fall back on that federal law of banning marijuana. I think at some point there's going to be some argument if probation departments can violate a drug now that's legal to everybody. So I expect a fight to happen later on down the road, but our probation departments go solely on the Controlled Substance Act that the federal law has. And I believe marijuana is substance 1 or 2. It's on there. So they're always going to fall back on that. And even our state officials, the state assembly, they didn't want our law to pass here, that law to pass here in Ohio, and they gutted that law pretty heavily when they had it on their table.
Yeah, and I mean, I find it very interesting, just and just so everybody understands, keeping everybody up to speed. It is legal in Ohio, but there's technically still a federal law that bans it. Now, I think there have been some statements made by the DOJ, and I'll probably have to refresh this prior to me actually putting this out just to make sure that I'm correct. But I'm pretty certain there are statements from the DOJ that they basically stated, "Hey, we're not going to actually go and enforce this unless there's a real reason to enforce it, especially with states that are legal." But technically, just so everybody understands, there's still federal laws against marijuana, even though a lot of states are legal. So that's sort of what we're talking about here. But
Right.
You mentioned several court rulings about alcohol and how it can't be a probation condition unless it's directly tied to the conviction. Why do you think probation officers still try to enforce those blanket bans?
Well, one, the probation department has a huge population, and I'm not trying to down people who are on probation, but some of them are uneducated. Some of them, have mental health issues and things like that. So they're not going to go out and look and see if their probation officer is telling the truth or not. They're going to do what their probation officer says. If the officer says, don't use alcohol, then they're going to do that because, they got that carrot that's hanging over their head, like you could face prison time. So they're going to do that. But when it comes to the alcohol ban, State versus Dockery, like I stated, it clearly states that, your case has to be tied to either drugs or alcohol in order to ban at least the alcohol part. I can understand banning the drugs part because drugs are illegal anyways. It's hard to justify someone doing heroin and then arguing, well, I'm allowed to do heroin because, a court ruling years ago. But, and again, they can enforce that rule because of that immunity clause that they have. I mean, if they want to, violate you on alcohol usage, even though there's multiple court cases, they still have that immunity clause. And also, when it comes to alcohol and everything like that, probation departments are going to try to, have that control still. They lose control if they lose control if they, can't take that alcohol thing away from you. So it's kind of, they want to keep control. They want to, make the judge happy. They want to make the prosecutors happy. So, they don't, probation departments don't go by case laws. They let the judge decide that. And that's why they can hold that over your head and continue to, violate you on that. They know that the judge is going to go their way in most cases.
I've also noticed, and I don't know if you've noticed it also, a lot of non-violent cases where people still end up losing their gun rights on probation, even though they had, it was a non-violent offense. So, or even a drug offense. So I mean, the law basically says you can't have a firearm if you're convicted of like certain narcotic offenses or certain violent offenses, but people get convicted of all sorts of things and they lose their gun rights for no reason. Have you, just curiously, it's not one of the questions I gave you, so I understand if you don't have an answer for it, but I mean, just sort of curious if you ran into any of
it. I actually have. It's interesting because years ago I studied protection orders, and what their effects and everything. And I even reached out to like right advocate groups here in Ohio, and they were against the cause of taking your gun rights away, even when a protection order was issued. Protection orders are issued like candy. It doesn't take much, get a protection order placed on you. At the same time, you're having your gun rights taken away, and the person that's putting the protection order on you don't have to prove very much in order to get a protection order. And that, so a lot of gun groups has actually argued that case here in Ohio, and I fully agree with them because we're taking away constitutional rights so easily anymore, and that's one of the issues I would like to tackle in the future. Is why are we just taking away guns so easily?
And I don't know if
and when it comes to the probation department, things like that, again, you're not allowed to
Mike, I don't
go
know
ahead.
if you saw recently, I believe it was the 8th District, which a court of appeals, which I believe is over Cuyahoga County. I don't know if you saw a recent ruling. Now, it was only one specific defendant. They didn't try to strike it down blanketly, but it was one specific defendant that just what we were talking about. They were given a temporary protection order, or a protection order of some sort was ruled against them, and they lost their gun rights. And the 8th Circuit stated, hey, that's unconstitutional. So I don't know if you did see that or not. The prosecutor's office in Cuyahoga County is fighting it. They're appealing the 8th Circuit's decision, but I don't know if you saw that or not.
No, I have it.
So
good for the higher court in that position.
Yes. You mentioned several court rulings about alcohol. Oh, I already asked that. In the article, you talk about the employment requirement being more collecting money and more than actually working any type of job. What should people understand about how employment is really used in probation?
Probation, let's take a look at my county. 85% of people that are on probation in my county are indigent. They rely on, state funding to get them through their probation, whether it's through public defenders and things like that. So putting a person, trying to get them working and stuff, one, it takes them off the street. I can understand that. It keeps them busy. Two, you got probation department fees. I believe in my county, it's $25. But in other counties, it can be as high as like $40, $50. So probation departments want their money, obviously. And two, you got court costs. And a lot of courts, rely on that court cost to keep functioning. So in the state of Ohio, for years, they never looked at part-time or full-time or defined them pretty, solidly. But in the last few years, we realized that now part-time is considered 30 plus hours, full-time is 40 plus hours. So getting a probation department to get their probationers working, benefits them, it benefits the court, it keeps people from being indigent, and that's how really employment works. I could probably say a lot of probation departments don't care if someone works, as long as they get their fees paid and stuff like that. But it also keeps them, the offender off the street and keeps them busy as well. Probation department, if you're making $20 an hour and you're only working 5 days a week, I've heard probation officers say that's suitable because they're making quite a bit of money. You can't force someone to work more, and as long as they're working and everything, probation departments are usually happy about that. Now, here's that willful, and I'm not going to look for a job, that would obviously be a violation because that's you're willing to not find some type of employment.
I did have, and again, I keep referencing Cuyahoga County as the one that I'm most familiar with. They have like
right.
Community sanctions. So a probationer has to do so many volunteer hours or whatever that nature is. And I find it sort of piggybacks off of what you're talking about. The probationer has to pay in Cuyahoga County. It's ran by a not supposed and I actually intend on looking into this a little deeper at some point. They are, it's ran by a nonprofit company. The court uses one company to monitor all probation hours, and the probationer has to pay for the monitoring of their working for free. And so I happened to ask one of the probation officers. I said, "Hey, what if somebody that can't afford these monthly monitoring fees?" And it was told to me that then they have to work more. So you have to work more free hours if you can't pay them to afford the monitoring fees. And then it's very interesting what jobs are actually picked by this nonprofit company. And again, it's to me, I don't know. Are the kickbacks going back and forth? Hey, I need free labor. Does a company approach this nonprofit? I just don't think that it's. I don't think it's transparent like many other country or counties, and so I just brought it up. I think it's odd that Cuyahoga County uses a nonprofit to monitor all of this.
Nonprofit working with, government, Cuyahoga County, their records would now be considered public records. And it would be interesting to see, who everybody, all about who in the system. So it would be interesting to see who has invested in that nonprofit. If it's, say, example, a judge's brother-in-law, the clerk of courts is, maybe aunt or something like that. It's and stuff like that into the system like that. Somebody knows someone there. It's just a matter of tracking who knows who.
So there's a powerful moment.
I had a similar.
Oh, go ahead. Sorry.
I had a similar case here years ago. Here, where I live, we had a busing company. Well, the city commission actually went with a Dayton company and got rid of the local company to do the busing service. There's only one city commission raised a fuss about it. He was saying, come hell or high water. Now, there's something going on here. Hell or high water. Well, later on, I found out that's one city commissioner and the Springfield Busing Company owner. They used to go to school together. They were on the same track team. They were buddies. So in your situation, it's like you kind of look at nations, and that's how I always I dig a little deeper a lot of times my answers. So I hopefully you can get some of your answers by digging deeper on that.
So there's a powerful moment where you highlight the contradiction between no contact with criminals and being allowed to visit someone in prison. What's your take on how those standards are applied in reality?
I feel that those are applied in reality is, like I said, in 2025, it's hard to come in contact with, someone who's broken the law. Everyone's breaking the law and things like that. When you look for employment, it's hard to find a job where you're working with someone who had a domestic violence case 5 years ago or something like that. I think what it comes down to is they don't want probationers communicating with other probationers and trying to figure out the system that they have in place. It's psychology. Like I said before, it's psychology. And we know that this guy has certain special conditions. This guy has an easier way to what you want to call rehabilitation, and that's another word that I dislike in the system is rehabilitation. If I'm supposed to have contact with known criminals or past criminals, aren't they rehabilitated? Aren't they rehabilitated back into the community? And I always found that funny is when you use that rehabilitation word, in your favor, probation departments they don't like it because it kind of undermines their agenda and what they're trying to do. But I think that what it really comes down to is they don't want, probationers, come in contact with other probationers and kind of put their heads together on what's really going on. And then when you had mentioned state prisons and jails and stuff like that, and we have to, probationers has to contact their probation officers in order to do that, but that contradicts, Rule 5, Rule 4 of what you had just said. If we're not supposed to be talking to criminals or, being around them, then why are we having to ask to go to state prisons or jails to visit people?
So for people currently on probation or parole, what's your biggest piece of advice? What do you want them to know, basically, how to survive this trap?
My article or public forum, I should say, I want it to be used as an educational piece, encouraging people who are on probation to break the law or try to wiggle their way around the law, or their probation in a sense. My advice is, if your probation officer says to meet at a certain time, meet at a certain time. Do what your probation officer says. You always want to do that. But keep in mind, too, that there are a lot of cases out there. Do your research. A lot of case laws that contradict some of what our probation officers do say to their probationers. Keep in mind, they have law enforcement powers. Law enforcement officers are allowed to lie to you to get information or to further their investigations. Probation officers will do the same. It's true that, once you do your research and stuff, there's a lot of stuff that probation officers are doing or trying to avoid that they really can't, because higher courts have, made decisions of you can't do this or you can't do that. I always, when I was, I think back to a guy by the name of Michael Larson. I don't know if you know that name, but Michael Larson sat at home and he watched a TV show called Press Your Luck, and he studied that game show. And he studied that game show, and he saw there was a pattern, and every time that pattern was on 5 or 6, it would land on big money. Once he got on the show, he played that same pattern, and he won over $110,000. They accused him of cheating.
I think I apologize. There's just like a huge delay between us, so I apologize. What Mike laid out is something I've seen from the inside as well. Probation isn't designed to rehabilitate. It's designed to control. It's not about second chances. It's about second traps. And thanks to immunity, nobody pays the price but you. If you're out there saying don't break the law and you won't get in trouble, ask yourself this. What happens when the law isn't broken, but they still say you did? Mike Walters is just one voice, but his voice joins a growing crowd that's tired of immunity, tired of double standards, and tired of a justice system that isn't just. Be loud, be heard, shake the system until the truth falls out.